Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Florida. Welcome to another Ask the Expert show, where for the last 16 years we have brought you the top experts in the field of legal, health, financial, and home improvement. We have got such a great show for you for the next 25 minutes. We get more letters about estate planning probably than any other topic of law or health that we do. And I know one of the reasons why we live in a state where the demographics are a little bit older, and that's why estate planning is so important. We have one of the finest law firms in Florida Senior Planning, PA, attorney Tom Olson. Good morning, Tom.
Morning to you, Steve, and all of your loyal listeners throughout the state of Florida.
It's Tom, I got to tell you, people love the way you respond to questions that we have from listeners, how you break it down where it's so easy to understand. And in this demographic, Tom, as you know as well as I do, it is so important because a lot of times when we get up there in age, maybe we don't understand everything, but you make it so, you make people feel so comfortable that they can send us all these questions. Tell people about Florida Senior Planning.
Well, first of all, thank you for that, Steve. And that's one of my God-given talents, is to explain the law to people in a way that they can understand it. That's the way all the lawyers treat the clients here at Florida Senior Planning. And it's just part of our job description that when our clients walk out of here, they have a full understanding of what they did and why they did it. Florida Senior Planning is estate planning for people anywhere in the state of Florida, from Pensacola to the Keys. We help people to do their estate planning, wills, trusts, probate, avoiding probate, helping to keep people in their homes up to 30 hours of free in-home care for seniors so they can stay home, how to protect their wealth from the cost of a nursing home. Steve, we offer a free initial consultation to talk about your estate planning. We can do that in person, over the phone, via Zoom, whatever you want. And when you take us up on that offer for your free initial consultation, once we get a little bit of information on you, we all agree on an action plan. We will be happy to quote you a flat fee. Hey, folks, there's nothing to lose. You're going to come out of it a more educated consumer. We'd love for you to do business with us. But otherwise, you can take that information anywhere you want to and use it and spread it around to your friends and family.
Tom, you really do walk the walk when it comes to educating the public. You do 2 shows a month with us. You have your own radio show, which you've had many years. How do people listen to your radio show?
Steve, I've been answering legal questions for people for 40 years. It is America's longest running legal radio show. It's every Saturday at 11 on WDBO.com. You can listen to it live streaming. Or if you're into podcasts like I am, just search your favorite podcast location for Olson on Law. That's OLSEN on Law. And we just send that as a podcast as well, Steve. On my hour show on Saturdays at 11, I answer people's legal questions. Typically, we get 15 to 17 legal questions in our 45 minutes of airtime. We often find that people with just a little bit of legal advice, that's all they need to get them on their way. Otherwise, we'll let them know if something more serious needs to be done for them.
You know, I think in your area of law, Tom, and this is not a put down to anybody, I think people procrastinate when it comes to estate planning law. Some of them think because it says estate planning, it means you've got to be a multimillionaire. None of that is true, right?
Well, people don't like to think about death and dying. That is for sure. But I can say on the other side of the coin, when you're getting your estate planning done with FloridaSeniorPlanning.com and we walk you to the door, you're going to feel like a weight has been lifted off your shoulders. You might very well turn to us and say, wow, that was easy. So folks, we know how to make the process simple. You're going to feel much better. Remember, folks, our goal is to make things simple, easy, inexpensive for your children when you pass away. People want to avoid probate because probate's expensive and it takes a long time. Florida statutes recommends an attorney fee to be equal to 3% of the value of those assets that go through probate when you pass away. So if you pass away and all you own is a $500,000 home and a $300,000 bank account, 800,000 times 3%, that's $24,000 to run those assets through probate. That's a lot of money. That's what we want to help you to avoid. But also, when things go through probate, it is a big opportunity for your kids to argue with each other, potentially never speak to each other again. So we're going to make things so easy for your kids when you pass away. There's not going to be a reason or an opportunity for them to argue with each other. It's all going to be a done deal. They're all going to still be friendly with each other.
Tom, I'm hoping with this show that people learn that they should not try to handle this themselves. I'm sure you've seen so many disaster stories of people who did try to handle their own estate planning. What can you tell people about that?
Well, Steve, first I want to let you know this, that we have free booklets available to you. We will mail them to you wherever you are. Booklets like how to avoid probate, how to avoid probate on your home, how to get free in-home care for seniors, how to protect your wealth from the cost of a nursing home. Those free booklets, easy. You can get them right now by calling 407-423-5561 or go through our website, floridaseniorplanning.com. So, Steve, when we do estate planning for people, we always do the 4 basic documents: a will, a living will, which is a pull the plug, don't keep you alive by machines, a health care surrogate. So if you're not able to, you're appointing somebody to decide what doctors, what hospitals, what medications, a financial power of attorney. So if you're not able to, you're appointing somebody to pay your bills and manage your financial affairs. Steve, if we do those 4 documents for a single person, the fee is only $1,200. If we do those documents for a married couple, 4 for him, 4 for her, the fee is only $1,500. So it's not that expensive. And that way you're going to have peace of mind to know that you got them done exactly right.
This is from Kathy in St. Pete. She said, I hope this isn't a dumb question. What's the difference between a will and a trust?
Okay. So first of all, when you hear people talking about trusts out there, they're all talking about the same thing: a revocable living trust. It is a tool to avoid probate. We consider it to be a complicated tool for avoiding probate. Most of our clients are using simple tools to avoid probate. At Florida Senior Planning, we're all about keeping it simple, and that's what people really appreciate. But a revocable living trust can be the appropriate tool for avoiding probate if you own real estate in other states. If you got a vacation home in North Carolina and you got oil and gas mineral rights in Texas, that's a good reason to use a trust. If you've got minor children, or if you've got minor grandchildren, young grandchildren that you want to include in your estate plan, that's a good reason to use a trust. If you've got children who are spendthrifts that would blow through your money if they got it all at one time, or if you have children who have alcohol or addiction issues, those are all good reasons to use a living trust. When you set up your free initial consultation with floridaseniorplanning.com, we will help you quickly figure out what's the best tools for you to avoid probate. Are we going to use simple tools, which most people do? Or are you a candidate for a revocable living trust? Hey, folks, if you're confused, don't worry about it. Just take us up on our free initial consultation. We will quickly help you figure out what is the best tools for you.
Here's a text wants to know, what is the difference between a general power of attorney, a limited power of attorney, and a durable power of attorney? What has changed in Florida regarding the durable power of attorney?
Okay.
And does a will mean that I'm avoiding probate court?
Okay.
It's a lot.
That's a lot. Let's break it down for you. So, a limited power of attorney is a power of attorney that is limited to a specific purpose. So sometimes you might be married and you and your spouse are buying a home and you're away traveling in Europe and you want to let your spouse sign documents for you while you're away. You might do a limited power of attorney where you're appointing that spouse for one specific purpose, and that is sign all documents needed to buy or sell a piece of property. It's identified by legal description or street address. So just for a limited purpose. Then the difference between a general power of attorney and a durable power of attorney. All powers of attorneys end when somebody passes away. So when mom does a power of attorney and mom passes away, that power of attorney, it is though it's been revoked, it's been ripped up, it cannot be used anymore. A general power of attorney also can no longer be used when somebody becomes incompetent. But a durable power of attorney also ends when somebody passes away. But a durable power of attorney stays in effect when somebody becomes incompetent. Most of the powers of attorney that we use for estate planning purposes are durable powers of attorney. So if mom signs a durable power of attorney and she's in a car wreck and comatose and you need that power of attorney to pay her bills, or mom develops Alzheimer's, she might live for many years where the child needs to pay her bills, talk to Social Security, talk to her home insurance company, all kinds of financial affairs. That's where you need the durable power of attorney so it can still be used once mom becomes incompetent. They're very powerful documents, very important documents. So most of our clients are using durable powers of attorney.
We're here with attorney Tom Olson. The name of his firm is Florida Senior Planning. What a great name. You know, we get a lot of letters all over the country with our other estate planning shows, and people are concerned that when the will was written by, let's say, their father or their mother, and they don't think they were of sound mind. What do you tell a client that
Yeah.
when the will was written, they don't think, what do you do, Tom?
Well, first of all, we missed one question on the last question. That is, does a will avoid probate? The answer is no. A will has nothing to do with avoiding probate. A will simply directs what happens to your assets when they go through probate. So people are often confused about that. They think, oh, I've got a will. My will says everything goes to my kids.
Yes.
When I pass away, my kids will go down to the bank with my will and the bank will happily turn the money over to them. No, the bank's going to lock up that bank account. It's going to stay locked up until some kind of probate is done. So then the other question, remind me what it was, Steve. Sorry about that. Real quick, what was the question?
It was about like a parent that you don't think was
Okay.
of sound mind.
So, Steve, in my 45 years of law practice, I've had plenty of phone calls that go like
Yes.
this. Tom, my mom did a will. She left everything to my brother. She was incompetent. She was medicated. She had dementia. I want to challenge that will, Tom. What do I do? Well, always step number one is you got to show me that will. They got to get a copy of that will. Now, first of all, we're making an assumption that mom has passed away because as long as mom is alive, you have no right to look at mom's will. But if mom passed away, whoever has possession of that will must put it on deposit with the probate court. Once it's on deposit, it's public record. Anybody can get a copy of it, including the disinherited child. So if I look at that will, Steve, and I see that it leaves everything to the brother, and oh, by the way, that will was prepared by that brother, and oh, by the way, the brother had his friends and family come and witness and notarize mom's will, where she leaves it all to that brother, hey, it's automatically suspect. More than likely, it can be overturned. If I look at that will and I can see that clearly it was prepared by a law firm, that it was witnessed and notarized by the employees and by the lawyer of that law firm, I'm going to say that that will is rock solid. So that's step number one, is always take a look at it. But folks, my 45 years of law practice, Steve, way back in the day, I used to read Ann Landers, the advice columnist in the paper, if you know what I'm talking about, if you're of
Yes.
that certain age, or Dear Abby, And Dear Abby's advice to all of her listeners was leave everything equal to your children. That is our starting point. As a client, man, you've got to give me some very good reasons why you are not treating your children equally in your estate plan. And by the way, when you give me those very good reasons, if I say, okay, I get it, I understand, I write those reasons down in our database so that when you pass away and the disinherited child tries to sue and they take my deposition, I can tell them this is why mom did that. And she had some very good reasons for it. If you're the client and you say, well, you know what, I got a daughter who's a teacher, she doesn't make much money, and I got a son, he's a doctor and he's loaded, I want to leave everything to my daughter. Maybe, but I'm still going to start with the position you should leave everything equally to them. If you came to me and said, Tom, I loaned my son money and he never paid me back, or while I was alive, my son never could make it financially. I've been giving him money all his life, even as an adult. That's why I want to leave more to my daughter. Those are all very good reasons. But if you want to challenge a will, step number one, you got to get a copy of it. You got to show it to a lawyer, get an opinion about the possibility of challenging that will. And by the way, Steve, it's the kind of interesting point that when there's a probate done and the disinherited child doesn't like that will, wants to challenge it, mom was incompetent or mom was under undue influence, and he hires a lawyer to challenge that will in the probate court, even if that disinherited child loses the case, even if the judge cites with the existing will and says it's good, we're going to go with it. Well, the child who challenged that will, that child's lawyer is going to get paid out of that probate estate. So if you want to challenge a will, you might very well be able to find an attorney that will do that for you, with that attorney knowing that he's not going to have to get paid by his client. He's going to get paid out of the probate estate.
Final question, Tom. Why should I hire your firm if I'm looking into estate planning, whether it's wills, trust, probate, whatever? Why should I come to your firm?
Well, Steve, check out our Google reviews. We have almost 500 Google reviews. They're all great and wonderful. Check them out. That's a lot of people get to us because of our Google reviews. But folks, first of all, we offer a free initial consultation, so you get a chance to meet and greet with us. No commitment on your part. Then we're going to explain to you what we think you should do in a way that you can understand it, just like I do here on your podcast. Then we're going to keep things simple. People appreciate that. Then we're going to quote you, once we all agree on an action plan, we're going to quote you a flat fee, so you know from the very beginning what it's going to cost you. Steve, when we do your documents for an estate planning for a client, we put everything in a notebook, nice and organized for you. We scan everything for our client, for our files. We put a scanned copy of everything on a thumb drive. By the way, when you retain us, we do an action plan. It's a one-page document that tells you exactly what we're going to do for you, because we explain it to the client here in our office and they get it. I understand they get it. They're going to walk, they're going to go home a day or two later. They're going to think, remind me what Olson's going to do for us. Well, we go back to the action plan. It lays it out 1, 2, 3, 4, 5. But that action plan also has written down for you what your homework is. So, Steve, we're about keeping it simple, explaining it to people in a way that they can understand, and doing a great job for them to make things simple, easy, inexpensive for their kids when they pass away. Steve, we'd love to take care of you, all the listeners out there. FloridaSeniorPlanning.com. We have free booklets on easy ways to avoid probate. We have a free initial consultation that you can do it in person, over the phone, via Zoom. Check us out, FloridaSeniorPlanning.com.
And one more time, Tom, when's your radio show?
My Olson on Law radio show every Saturday between 11 and noon. You can listen to it live streaming at WDBO.com. WDBO, affectionately referred to as Way Down by Orlando. WDBO.com live streaming. If you like podcasts like I do, there is an Olson on Law radio show podcast. That's OLSEN as Olson on Law radio show.
Tom, you're the best. Tom's with us twice a month, and we'll see you next month, Tom.
Yeah, Steve. And by the way, we got people standing by to talk to the listeners right now. Give us a call, 407-423-5561, FloridaSeniorPlanning.com.
Anywhere in the state of Florida.
You got it.
Tom, thank you so much.
Thank you, Steve.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.